Thanks again. I see you again, everyone. I'd like to just start by just saying something. In your booklet, it says that Justice Subramaniam from India was supposed to join us today for this particular session. He really wanted to come, but there, circumstances are such that he couldn't. It was just beyond his control. He has been great. He immediately, worked on a paper and he emailed it to me. So we'll make it all available to you. We'll email it across to you as well. He contributed 2 decisions to this booklet. So, I hope you read them as well and learn from them. He emailed me a message, a personal message that he'd like me to read out to you, so I'll just read it out. It says here, message from Justice V. Subramaniam, Judge of the High Court of Judicature at Madras, India. In the name of one of the ancient civilizations of the world, where thousands of years ago, the Rig Veda declared law and truth as eternal, I wish all the participants and the distinguished invitees of the LexisNexis Rule of Law Conference my best wishes. The High Court to which I belong celebrated its centenary only last year. Therefore, on behalf of such an institution, which is 150 years old, I send you my greetings. Though I missed being there physically due to reasons beyond my control, I could visualize that all of you, by your individual and collective contributions, would make the event a grand and memorable one. So I'd just like to acknowledge and thank him for his work so far and just say that we'll miss him at this session. But we have Judge Downing here, who has so kindly agreed to fill that seat. So we will be really grateful for that as well. And everybody's already smiling, so you've already heard him several times. And I think, Judge, this time you need to spice it up a little bit more, because you've already set the bar quite high. So we were looking forward to that as well. So I'll just carry on. What the topic today is, it's called a comparative approach in judicial decision making. So that's the final panel session of the 2-day conference. And the vision is that all of us talk to the judiciary. Many of us in LexisNexis talk to members of the judiciary in many, many different jurisdictions. And in a lot of the cases, we ask, how do you learn? What happens? How do you get out of, business as usual, so to speak? And many talked about how much they learn from looking at laws and referencing laws and learning from laws from different jurisdictions. So that is the focus of the topic today, a comparative analysis. When do they reference laws? How useful is it? What is the future going to be like? And their personal experiences, how it has helped or challenges they face as well. I'll introduce each of them a little bit. 2 of them you've already heard from, Judge Milart. I first was connected to via Andrew Cayley. I had a conversation with him. He connected us via email, and then I had this conversation with Judge. At that time, the program was barely developed. I just had a lot of passion for this topic, and Judge Milart helped me solidify it with her passion as well. I told Sean, I felt like I was going through an LLM course, talking to them without the boring exams and, stress of everything else. But it was great engagement. Same as Miss Susila Sithamparam. I've known her for 10 years. Her passion hasn't waned at all. It's the same, she's president of the industrial court in Malaysia. That's the labor courts in Malaysia. And she's the head of the industrial court. And she's equally passionate about, looking across, outside Malaysia when helping her make decisions. And Judge Downing, he's really good at tango. We'll just put it out there. Hopefully he'll perform for us. But again, he's equally passionate. Andrew again connected us. And I had this conversation with Judge Downing as well. He talked about financial crimes yesterday, but he was equally passionate about this topic as well. And that is why I went to him and said, can you please rescue us? Well, actually Judge Milart said, just tell him, he'll come. But yes, you know, this ends it. This wraps it up. But I hope we all get great engagement for from all our judges. So we'll start with Judge Milart.
Good morning. It is a great responsibility. It feels intimidated to be on the final panel as we were announced. But yes, the moment has come. Indeed, regarding comparative approaches, it is a very, very interesting subject for us at the ECCC. Having been a judge in a comfortable setting of a fairly developed legal system in Poland, a continental system that actually provides answers to all the problems in the written law, I did not appreciate the wealth of comparative study until basically having started adjudication in the Cambodian setting. We do apply international criminal law when it comes to the definition of crimes, modes of responsibility for the international crimes. But what I want to talk about now is how we were driven towards comparative law and comparative perspective in the area where we are supposed to apply domestic law. Namely, when it comes to the procedure applicable before the ECCC, it is based on the founding treaty. It's the domestic Cambodian criminal procedure which is applicable. And we are only authorized to depart from the Cambodian procedure if there is one of three instances listed in the treaty, namely when there is a gap, or the manner is not clearly regulated, or the issue is, the matter contradicts international standards. Then we can derive from rules established on international level. Yet, the criminal procedure that is applicable in Cambodia is not does not provide all the answers that we need. I spoke yesterday about the implants from foreign systems, and this is probably one of them. And it is not unfortunate, but perhaps it still illustrates the thesis that you cannot import just the dry letter of the law without considering the context of jurisprudence that accompanies it, and considering the context of the local context and the judiciary that is supposed to apply it. And what happened was that for the Cambodia, the old, dating from the 50s, code of procedure from France was copied or modified for the Cambodian setting, but France has huge jurisprudence that explains it. And France has also the jurisprudence of the Strasbourg Court of Human Rights that further clarifies, especially the interface of the state power vis-à-vis individual rights. And France has strong judiciary with this all wealth of jurisprudence. This is absent in Cambodia. So we were left with this dry or even further simplified provisions imported from France to Cambodia. And we had to deal with it in our circumstances of international crimes. And so on the face of it, this is the continental system, this is the positive law, and we should be construing upon the law that we have at hand. But we quite often find ourselves in the area that is not regulated by this law, and we have to still find the answer. And here where the comparative perspective comes in handy. And I wanted to mention a case that is available on the internet, one case before the ECCC where the comparative perspective was particularly helpful. I sent this case before, but it is not included in the materials. But a case concerning one of our accused, as to whom it was found that she was unfit for trial due to a psychic condition, suspected Alzheimer's disease. She was found to be unfit to be tried. Prosecutor Mr. Andrew Cayley spoke briefly about that case. So we were not just testing the humanitarian approaches in the court. We were testing the capacity of the procedure to address this issue. And we were also testing our capacity of the court to deal with this question, because we were all very passionate about it, those who were involved. And the whole court, all the offices and chambers of the court that were involved in the issue were working very hard to push the questions to its limit and to find the answer. And it fell upon us on the Supreme Court to actually to provide the answer that will be final for this court, but of course subject to public debate and possibly different solutions. However, to quickly tell you the background, Gaythri, accused of crimes against humanity, war crimes, genocide, was found unfit for trial due to Alzheimer's disease. The first time around, the first instance court decided she'd be freed from detention, and the proceedings put on hold, stayed. This was appealed before us, and we were not quite convinced that one-time evaluation by the psychiatrist was firm enough to be followed by such radical conclusions. And we ordered re-examination, and we continued the detention for the time being until this revelation could happen. There were some treatments recommended. So after a couple of months, the case came up a second time round, and the psychiatrist, the panel of specialists found her again unfit for trial, and said that, you know, with the certainty that you can expect from medical profession, meaning there is always a margin of error that they allow themselves. They said the most likely Alzheimer's disease most likely will never be cured in this in her lifespan. So the trial chamber again freed her from detention and stayed proceedings. And the trial chamber said that they had no longer jurisdiction upon her. It came before us on appeal. And we said, okay, the trial chamber is stubborn, the prosecutor is stubborn, and we also braced ourselves and said, okay, there was a bunch of international cases before ICTY that were cited in this dispute that showed that even permanently ill, in terminal conditions accused were not discharged, but remained charged. And on humanitarian basis, only the detention was interrupted. But these were terminal conditions, and actually none of them lived long enough for this difficult procedural situation to have any further consequences. Our accused was is still in quite a decent shape. So it was not that we could expect a sort of our question being ended in a different way. We had to resolve the question of a permanently unfit accused who is, however, charged with the most serious crimes known to humanity. So what did we do? And bear with me, because it's not included in the materials. So this is what there is, like 10 paragraphs that are the most important, and So we said that it is a complex issue. And he said it creates a tension between the fundamental rights of the accused. On one hand, it is to be presumed innocent, to be tried within a reasonable time, as well as the rights to liberty and privacy, among others. And the interest of justice, on the other hand, in prosecuting the accused for serious crimes, including the interest of the victims to have the truth ascertained and pursue their civil claims. In this context, we said, we, the Supreme Court Chamber, shall examine whether the solution drawn from Cambodian law and based in retaining jurisdiction over the accused is compatible with her fundamental rights, or whether international standards or general principles of law would require the termination of the proceedings or yet another sui generis response. To that end, the Chamber has conducted a survey of the rules and practice established at the international level as well as domestic practice. As more amply discussed below, this survey shows that legislators and courts have struggled to find concrete solutions to deal with the accused unfit to stand trial, especially when the prospect of a trial is remote, and that various approaches have thus far been developed. These can be grouped into three broad categories: to suspend the proceedings without terminating them, within an option to employ measures aimed at facilitating the resumption. Second, to bring the proceedings to a conclusion by deciding whether the accused committed the act with which he or she had been charged, with an option to impose a range of measures aimed at protecting the accused and the public as necessary. And third option, to terminate the criminal proceedings, and again, with the possibility to deal with a matter pursuant to mental health provisions of the like. And just to impress you, first solution to suspend the proceedings, what we examined was Germany, Italy, Poland, Russia, Netherlands, Albania, Bosnia, Argentina. Other countries, Singapore, India, Botswana, Israel, Honduras, have adopted the solution that, that the proceedings are stayed, yet the criminal court exercises jurisdiction to the effect that certain measures that aim at exercising control over the accused are still valid, are still available for the court. We also amply cited French jurisprudence, French Court of Cassation, that also expressed this opinion that the proceedings are suspended, yet the court should take necessary measures to ensure that the rights of all the parties are protected. Then the second approach, meaning with this review, we found that the issue has been subject to the debate on the highest constitutional level in two countries. We found that Italian Constitutional Court was seized of the matter, and the Canadian Supreme Court, Constitutional Court, Supreme Court was seized of the matter, and the Italian court took a very civil law type position and said the proceedings cannot be terminated, and as long as the person is alive, and because especially the mental fitness is an issue subject to error and deceptive behavior of the accused, the court is empowered to exercise jurisdiction as long as necessary, as the law allows it. That means basically until the statute of limitation lapses, or ultimately at death. Canada was not as straightforward in favor of prosecution. The Supreme Court of Canada found that the tension between the presumption of innocence and the interest in prosecution could be resolved in favor of termination of proceedings. Yet, the court was not bold enough to say, in every case where you have a permanent unfitness, go and terminate the case. The court said that it depends inter alia upon the gravity of the charges. And then we said, okay, we are at home. No court of these jurisdictions said terminate proceedings and let the psychiatrists terminate the proceedings. We do not trust the accused, we do not trust the science, we do not trust the doctors. And we are hoping for the good in the methods of treatment, wherefore we retain jurisdiction, and to the extent it could be proportionate under the circumstances, measures of certain court supervision over the accused remain valid. We then moved on to the second approach, which is one favored in favored in common law jurisdictions, which is to examine whether the accused actually committed the act attributed to him or her, at least whether the actus reus could be attributed. And we found that United Kingdom and Hong Kong and Zambia and Australia, where criminal proceedings against unfit accused, permanently or not, are brought to a conclusion by authorizing a court or a jury to determine whether the accused has committed the act. And in the affirmative, the criminal courts are competent to order a variety of measures. So we surveyed this and these jurisdictions. It was a relatively narrow group. And the third approach was in the US, to some extent Canada and Serbia, Chile, Kosovo, Liberia, Sierra Leone, and Tanzania. So rather in-court jurisdictions that simply, I think, adopted the solution as a matter of practicability, of pragmatics, where, and also the jurisdictions that were not bound by the principle of mandatory prosecution, where they say permanent unfitness, you may terminate the proceedings, and it's upon the prosecution or the court, whichever organ ultimately decides on the termination, to assess whether in the circumstances of the case there are solid enough grounds to terminate the proceedings, or whether to keep them suspended without disposing of the case permanently. So I have to say that without the access to various databases, we wouldn't be able to dispose of this matter with the I would say, strength and conviction that we had, that we did the right thing. And in the end, this decision was accepted by the general public. And as much as the first time around, it was still subject to discussion whether indeed to retain jurisdiction, to retain detention, to carry out examinations was appropriate. After the second decision, I think we managed to convince the larger public that our position had solid basis in the practice that was applied elsewhere. But of course, the matter as a question of resolving the tension between the presumption of innocence and the interest in prosecution remains valid. We, of course, disrupted the detention of the accused, and we only ordered that there be an evaluation of the fitness and some repeated medical examinations. So here's this example that is still sort of fresh from the ECCC. Thank you.
Thank you, Judge Milart. We'll make. I think we probably missed, including this into the booklet. What we'll do is we'll email this particular judgment to all of you as well, and then we'll make it available at a later stage and publish these. Really, really useful material as well.
It's not a frequent situation, though.
I have many questions, but I think we'll get through this, and then we'll have Ms. Susila and Judge Downing talk as well. I think one thing that I'll leave I'll leave this question open for Ms. Susila as well, is that I had so many countries. I think everybody, started, reacting to the fact that you were reading out so many countries. I wanted to take it down, and after the second one, I thought, okay, it's going on and on. My question is, because you're an international judge, is this more so for you? And then, when it comes to Ms. Susila, you are in one particular jurisdiction, you deal with Malaysian law all the time. Is that very different, or, how similar are you, or are your approaches and challenges? I'll leave that. And Ms. Susila?
Ms. Gaythri, Raman, honorable judges and ladies and gentlemen, a very good morning to you. And thank you, LexisNexis, for inviting me to present my paper. To answer your question, the reason why we have, in our decisions, made reference to decisions of the courts in the United Kingdom and also from the Commonwealth is because of history and an access to knowledge. Given time, when knowledge from Japan and the Netherlands is made accessible to us, and I'm sure it is going to be in the field of technology, we will want to follow precedents from those jurisdictions. Traditionally, we have had a strong link with the United Kingdom. We were part of the British Empire, and I'm happy to say that the judiciary has been proud of this legacy. In all the decisions of the Court of Appeal, the Federal Court, which is the highest courts in the country since independence, they have acknowledged the inheritance of the British law. And from this foundation, we are going to build for the future. The modern industrial law in Malaysia started in 1967 when we had the current legislation, which is the Industrial Courts Act of 1967, which has been inspired by a lot of concepts from Australia, where we have used the phrase equity and good conscience. It is found in a number of the state legislation of Australia. The concept of compulsory arbitration was first practiced in New Zealand in 1894. So compulsory arbitration in industrial disputes is a form of dispute resolution where the parties do not have a choice. The state intervenes, in this case, the Director General of Industrial Relations. He can take cognizance of a trade dispute. But the jurisdiction is conferred by the Minister of Human Resources, which is unique, I think, in the common law systems, where the minister has a direct role. So our jurisdiction in the industrial court is conferred by the minister. But once he refers the matter to the industrial court, we function independently. So this independence has come about because the presiding president, who is the head of the industrial court, and the chairman who sit in particular disputes are trained in the common law. So I never studied, I read law at the University of Malaya, though I studied law locally in my own country, but this tradition of judicial independence has been imbued in all law students, and we hope that it is reflected in all our decisions. In industrial law, the legislation is, I think, a very good piece of law because it gives a free hand to the courts. All it says, you decide according to equity and good conscience. And this rings a bell, I think, for anyone. It is a universal concept, what is conscience. And when we can strike a universal resonance, I think it will be for all times. But for the time being, the development of a case law has been peppered with decisions from the United Kingdom, and we continue to do it with decisions from Australia and New Zealand, simply because we have access to the law reports. LexisNexis has come about with a local publication known as the Industrial Law Journal, which is published by LexisNexis in Malaysia. And they include basically Malaysian cases, decisions of the industrial court, a superior courts, and also a comparative approach of decisions mainly from the Commonwealth countries. So we depend on publishing houses like them to bring this information to us, and hopefully we'll see some decisions from Netherlands and Japan in the Industrial Law Journal of Malaysia. So as our knowledge widens, we try to embrace concepts. Now, historically, our laws were enacted by the British colonial government. Even before independence, we had the first legislation in 1940. We had 3 pieces of legislation to cover the administrative setup then. We had the straight settlements. So we had the Industrial Courts Ordinance 1940 for the straight settlements. Then we had another administrative entity known as the Federated Malay States. So another piece of legislation, the Industrial Courts Enactment of 1940 for the Federated Malay States. And we had 5 unfederated Malay states, but out of the 5, only one state, the state of Kedah, enacted the legislation. But the calendar is 1360, which is the Muslim calendar instead of the Gregorian calendar. So you have the Industrial Courts Enactment 1360 of Kedah. So with this legislation, the beginnings of industrial law took root. So a lot of our legal development is by way of a transplant, but it becomes our law when the local courts have endorsed it. And we had a link also with the UK through the Privy Council. Until 1985, our decisions from civil decisions went to the Privy Council. And that is a direct precedent which is binding on us until it's been set aside by the highest court, which is the federal court. Why administrative law is linked to industrial law is because the industrial court is a tribunal. So the link to the high court is by way of judicial review. So the development of industrial law of administrative law has been contributed because of decisions on judicial review of decisions of the industrial court. So we find that industrial law, it is not strictly the relationship between employer and a trade union. By the way, we also have the jurisdiction to decide on dismissals of individual workmen irrespective of whether they are members of trade union. Company law is also relevant because a lot of employers today are entities incorporated, and shareholders may be foreign shareholders. So because of our foreign investment requirement, if a foreign investor were to do business in Malaysia, they will have to incorporate a company in Malaysia and have an equity which is shared by local. Then they will be given licenses to do certain businesses. For certain businesses, there's no restriction. So a foreign company from overseas can have a direct presence in Malaysia, but there's a requirement under the Companies Act for them to register their office in Malaysia. Otherwise, they'll be flouting the Companies Act. And so our laws now must be respected and acceptable to the international community. We are very mindful that this is one of the reasons why foreign investors would want to invest in Malaysia, because they know that there will be an impartial body to decide on trade disputes. Our trade unions are fairly strong, and they will not hesitate to invoke the process of the law. So in jurisdictions like Japan, they're quite perplexed, when there are a lot of cultural contradictions when it comes to issues. Recently, I had to decide on a matter where a Japanese company had refused to pay bonuses to the local workmen, and some of the workmen were from Indonesia. So we are seeing the impact of globalization in industrial law by way of the labor flows, capital flows. And all the more, we must follow international norms. Of course, Justice Downing has posed the question, what do you mean by international? So I will say it's universal. I hope that it will cut across all jurisdictions and be acceptable. So I have given illustrations of administrative law. Now, although our appeals to the Privy Council ended in 1985, but our law on our administrative law has not stagnated. We have continued to look at developments in the United Kingdom, where they are now mindful of the human rights component in individual liberties. And we have the expression right to life in our federal constitution, which is a written constitution. India, which has a written constitution, also uses the same fundamental liberty, right to life, which has now embraced the concept of right to livelihood. So I will say, not only do we recognize security of tenure, but it's also a constitutional right because it's a right to livelihood. So when it comes to decisions on constitutional law, we look at the Supreme Court decisions from India, but with a caution in mind. The Indian written constitution has directive policies, like social justice, secular system. So our courts, there's a decision by a High Court judge where Edgar Joseph, in the decision on Waikin Eskim, he has cautioned what the Lord President Safyan in another case had said. We cannot follow the decisions of the Indian Supreme Court in total because they have directive policies, and we have our laws, and constitutional law must be interpreted in a contextual way. What are the local circumstances? Right from the beginning, when the first Charter of Justice was given to the Strait Settlements in Penang in 1894, there was this clause that it must be suited to local circumstances. So family law, that was the first reception of British law, was family law. But polygamy was being practiced, and how could polygamy be outlawed? Otherwise, there would be scores of illegitimate children. So very mindful, they recognized common law liaisons, and finally, for non-Muslim marriages, we have the Law Reform Act, which abolishes polygamy, but for Muslims, they are allowed under the Sharia law. Now, coming back to industrial law, as I said, we have to be mindful of the labor flows and capital flows. So all our case law is on maintaining the industrial harmony. We have the statutory provisions where we have to take into consideration implications on the economy of the country and the financial implications of businesses in that particular industry. So the Act recognizes security of tenure, but modern businesses need to reorganize. And traditional concepts on redundancy, that there was a cessation of work, that the job no longer exists. We followed this principle, which is found in an English Employment Redundancy Act. Of course, that act doesn't have direct application, but of recent times, in case law, we have developed to say that redundancy can also cover a situation where the work continues to exist, but because the restructuring has to take place, there may be a loss of that job. So, and this is borrowed from the Fair Work Australia. Again, the Fair Work Australia Act of 2009 has no direct application to us. But it's the concept which we have embraced on what is redundancy. So if we are that wise, then all these ideas will just flow into us. But for the time being, we have the benefit of seeing what is the collective wisdom of judges from all jurisdictions. And we happily embrace these concepts. And I think the paradigm shift will come with technology. There will come a time when the employer and employee relationship will be in cyberspace, and jurisdictions will now have to decide, now for your relief and remedy, which court will have the nexus, which court will have the primary jurisdiction. We are seeing it because in work now, which is transnational in nature, we've seen it in 2 cases in Malaysia in the industrial court, where we have Malaysian companies employing expatriates, but who are working outside the jurisdiction. We have the case of Katrivelu Ganesan. He was a Singapore national employed by a Sri Lankan national employed by a Malaysian company, but sent to work in Singapore, where he was dismissed. The Supreme Court, federal court was known as the Supreme Court at that stage, said yes, the industrial court has jurisdiction. In another case, which involved an Australian expatriate, he was employed by a Malaysian company, NICAP Asia Pacific. He was not given a work permit by the Malaysian immigration. He was sent to work in Thailand, where he was dismissed. Again, the High Court upheld the decision of the industrial court to say we had the jurisdiction. So the transnational nature of work makes us more conscious that we have to look beyond our shores to see how the law is developed. And as I said, the challenge will come when technology directly affects the creation of the employment relationship. See, on this note, I look forward to reading all your judgments, future judges in the audience, and also LexisNexis will be our friend in this respect. Thank you very much.
Thank you, Ms. Susila. Now we'll have Judge Downing speak.
I feel as though I've been thrown in the deep end. I'll try to swim. There is, I think, within the common law and in the civil law system, a view that we're in bubbles, and that in the common law system we've got this perfect system, and equally the civil law system think they have a perfect system. In fact, neither has a perfect system. From my jurisdiction in Australia, the only civil law cases that we apply are effectively Swiss constitutional cases, because our constitution is in part drawn from the Swiss constitution as well as the American constitution. But we, like Malaysia, we apply cases from all over the Commonwealth because they are common law cases, and we have a similar system. Within the international area, it's as if the bubbles, the civil law bubble and the common law bubble, have been burst, and we are exposed to both. Do we take the best of both? I'm not sure. One of the difficulties for common lawyers is a linguistic difficulty, because a lot of the cases in the civil law, whilst they are erudite, most learned, they are not available in English or in another language that we understand, and therefore we are very limited in the manner in which we can apply them. And I think that that's a great shame, because we lose a great deal of wisdom. It's perhaps easier for those in Europe because to refer to common law cases because they're in English, and most Europeans, luckily for us, they speak English, but we don't speak many European languages by and large, so we're restricted. Within the international courts, and particularly the ECCC, we find ourselves, and Agnieszka has given an example of this, of doing surveys sometimes, because we are a hybrid court. We're dealing with situations which are very often novel. We have to try and make things sit within an overall perspective that makes some form of rational sense. So we will undertake a survey. And I wouldn't want to give LexisNexis a plug, but it's the only system that certainly in my chambers, that we have, which provides us with access to a great number of jurisdictions in order to be able to undertake these surveys of what are the domestic laws in a number of countries. So we try to bring whatever we can together in order to make these rational decisions. It has to fit within an international matrix, and that is the most important thing for us. So we look at that as well. Intellectually, it's quite a difficult exercise sometimes. But I would also like to look at the precise words of the topic, comparative approach in judicial decision-making. And I would like to give some examples, and I now just give the normal disclaimer that nothing I say relates or can be taken to be said on behalf of the United Nations, and the Chatham House rules apply to what I'm about to say, but I don't think I'm going to breach any confidences, and if I do, my sister in the law here will no doubt tell me. But I'd like to give you an example of some of the things that have occurred in my court. We had the first deliberations, or my part of the court, of any part of the ECCC. I had a Dutch colleague, and she's a very strong woman. And initially in the court, she knew what my views were about interjection, because I come from the common law system. And before we went into the court, she said to me, "No, I don't want you to be a rude common lawyer. I don't want you to interject. So can you please just wait for your questioning of counsel until the end of their address? It's very, very rude to interrupt them." And I said to her, "No, look, I'm a rude common lawyer and I will behave as a rude common lawyer. And if I don't understand something, I will interject. Because I don't want to be in a position where I have sat and I've been exceedingly polite to counsel, and counsel has gone for 45 minutes addressing the court, and at the end of the 45 minutes I say to counsel, 40 minutes ago you said something I didn't quite understand. Could you clarify?" So I decided that I would be the rude person, and within the first 5 minutes I had to say to François Roux, who was a Frenchman who was appearing before us, "You've just said something I don't understand." And he looked absolutely horrified. He had never before been stopped in the middle of an address, and he didn't know what to do. I totally upset his train of thought, I think. But at least his answer clarified my question, and I did understand, frankly, what he was attempting to say. We then came to our first deliberation, and it was a very interesting exercise for me in the comparative approach of judicial decision-making. Judge Lahaus from the Netherlands and I were, I think it's reasonable to say, at each other's throats during deliberations. We were screaming at each other, we were yelling at each other. Every time one of us would put forward a proposition, the other one would go for the jugular. And the poor president of my chamber turned to me and he said, "This is not the way we do it. It's normally consensus." And in Cambodia, that means the president goes in and says, "Well, I think this," and all the other judges go, "Yes, yes, that's a good idea." And the president said, you're having a discussion. And I said, "No, we're having an argument. And this is a Greek methodology. We are testing every single proposition that we are wishing to put and to advance. But don't worry, we will come to agreement." And he looked at me in absolute disbelief to think that we would come to agreement. And sure enough, after 4 or 5 hours, Katinka and I were in heated agreement. And there was a sigh of relief from our Cambodian colleagues. The next deliberation we had, Katinka and I were again at each other's throats. And to our amazement, the president joined in and started thumping the table. And he was taking part in this aggressive Greek approach to the resolution of problems. The next deliberation we had, there was another judge who started banging the table and throwing books around, and it was very vigorous. And I saw that as a comparative approach to judicial decision-making as actually being a great advancement. I thought it was very good indeed. We then had another case in which a member of council had not taken an objection to an issue of rights, and it was the right to his client to be informed of his right to remain silent. And this was a French lawyer, and he said, oh, no. This right is not something which you are given at the start of every interview, or if there is a break in the interview, you are not, there is no refreshment of the right to remain silent. In the French system, which we apply here in this court, we talk about stages. And the first stage is the stage of charging, arrest and charging. The second stage is the stage of indictment. The third stage is the stage of trial. Now, if you're dealing with elderly people who may have short-term memory loss, this causes some problems. I didn't say that, by the way. But we, both my Dutch colleague and I, said, no. The international standard here is that if you start an interview on a Thursday, you start it with informing the person of their right to remain silent. And if you go for a cup of coffee and you stop the interview, when you resume the interview, you remind them of their right to remain silent. And on the Friday morning, you do it again. And our colleagues, our Cambodian colleagues, were really quite surprised because that was not their tradition. It was not the way in which they approached the decision-making in relation to people's rights, but they adopted our procedure because Katinka and I both asserted that this was indeed the international standard in relation to people's rights, and it complied with the International Convention on Civil and Political Rights, which we were bound to deal with. Now, I would also like to deal very briefly with the nature of the judicial process, a comparative approach. We may have different approaches, but the one thing that I've found as an international judge, and the one thing that I have rejoiced in, is that we are all members of the human race. We all have different cultural, different societal differences. We come to problems from a slightly different perspective, but we all have the same problems. It doesn't matter what society we live in. We all have the same problems. We have different methodologies as lawyers of analysing those problems. But the delightful thing is that invariably we will come to the same conclusion. So that the comparative approach, the different approach, will get the same decision. And I rejoice in that as a lawyer. I think that it's something which binds all lawyers together, whether we are from the civil law system or from the common law system. It is the most wonderful thing. And I think that organisations such as LexisNexis will in fact be a catalyst or part of the process of bringing legal systems together. If we look at Europe, the systems are being brought together. The common law is moving more towards the civil law, and the civil law is moving in part towards common law. I look at Australia. We have a codification of our Theft Act, which we got from England. England, I suspect, got it from the continent. We have a codification now of our corporations law, and many of our laws are now the subject of codification. We have an administrative tribunal which is based entirely upon the French administrative tribunal, even to the rules being merely translated from French into English. So there will be in a very short time a merger within the global village of laws, particularly in relation to areas of commerce. And those of us who are common lawyers here will, of course, recall that mercantile law, which talks about conformity with sample, requirements in relation to quality, requirements in relation to delivery times and the like, relate to international trade. And now we are involved in more than just international trade. We're involved in a global village. So the laws will merge as a consequence. So that the comparative approach will become an approach of commonality. And I'm looking forward to that because there is the commonality of problem. And even at international human rights law, it's an assertion of common values that we are looking at. It's not a comparative approach that we apply, it's a commonality of approach. And I think that that's very important. So I'm sorry, I may not have done the tango, but that's the best I can do within the time. But I also, just one parting gesture, the judges from the civil law system, they search for the truth of the matter. I think that as common lawyers, this is a most enviable position. We're not so concerned with the truth of the matter. We're quite often concerned with who's the best performer in court. If we have juries, the juries look at who is the best advocate. Are we actually doing justice in respect of the cases that we deal with, that are before us? I don't think that we do justice in the same way as is done in the civil law system. I think that we let people down. I think that we let victims down very much. Equally, there are some problems in the civil law system, but I won't address those because I'm sold on the civil law system. I'm now very critical of the common law system, the adversarial system, where the judge becomes the referee or the umpire between two gladiators who are sent in. And we had the example yesterday, I think, or may not have been made public, but there's a case going on here where silk are being brought in from London at a cost of millions of pounds. And that's because they're regarded as the top gladiators. Well, that's not what the law's about. It's not a gladiatorial event. It's not a sport. It's to do with justice. It's to do with truth and finding the proper way through a problem to get to a result which is truly just. But I don't think we do that in the common law. I think we need to adopt some of the practices of the civil law. Civil law needs to adopt some of our practices, maybe cross-examination with the leading questions. So that's about all I have to say in relation to decision-making and the comparative approach.
Thank you. Thank you, Judge Downing. I have many questions, so I know you will have them as well. So I'm just going to sum up what I heard from you, Judge Downing, is that there are a few things here, and from everyone here as well. Technology, trade, society as well, that is forcing us to compare and contrast laws. And I think, in a nutshell, things are moving so quickly we are just, we are crossing states, crossing nations, cyberspace, communicating across jurisdictions so often, so frequently, all the time, that it's second nature to us, and all these comes with a lot of follow-up questions as well, which we cannot deny any longer. And it's great to have judges from civil law jurisdictions and common law jurisdictions talking about what works in the other jurisdiction and wanting to change some of the things internally as well. I think that's magnificent. I think that's the way we are going to proceed, move to the future as well. My question here is, what about, how feasible is it to have regional tribunals, regional courts? You are international judges, but how do you see that evolving? How important are those as well? I'd like to hear about that in terms of human rights, for example. We hear about polygamy. I've always, sometimes, like in LexisNexis, we look at publications and we say, oh, financial crimes, this definitely cross borders. Then we look at a criminal procedure and we say, oh, this is national, this is local. And then we hear a lot of, examples here about questions with regards to procedure as well, criminal procedure, and it's not that local. We had so many countries here. And then we think family law, and we think, oh, family law is local. It's national. And then we think, well, wait a minute. We adopted this part, we didn't adopt this part. Polygamy is something that we won't. Other areas, yes. Again, everything is international as well. I would like to, pose this question to the panel. How do you see that happening, and do we need those regional courts as well? Josh Downey?
There are many regional courts. There's the Inter-American Court. There is an African Court for people and human rights. There's the European Court of Human Rights. And these are very important. The one thing that we don't have, of course, is the Asian Court of Human Rights. The issue also is, should they be limited to human rights alone? What do we do about the transnational companies which are in dispute? Is there not room for consideration of commercial disputes, transnational commercial disputes? There should be courts for those. I think, though, the problem is a lack of political will and transfer of jurisdiction, lack of sovereignty, or the transfer of sovereignty to international courts. So I think it's unlikely to happen. But just in passing, one of the things that I just suddenly realised in relation to polygamy, from a male perspective, if you had 4 wives, I just can't imagine what it would be like if the 4 wives joined together to divorce you. You'd have absolutely nothing left. It'd be appalling. So I'm sorry to have made that comment, but it's maybe that should be at an international human rights level. But I think that there is a place for the international courts to bring international standards as a whole intellectual property is an international area. There would be no reason why there couldn't be regional courts in relation to that. But there are international, am I right? In fact, no, you don't have an international court in relation to IP, do you? Not yet. Yeah, but there is, for instance, in relation to the law of the sea, World Trade Organization. There are quite a number of international courts which deal with specific issues, and I think that there is a great deal of room for the development of those.
Thank you. One thing I wanted to ask Puan Susila, yes, is that this applied to Malaysia. So remember Malaysia, very recently, Malaysia, Singapore, we talked about it, the haze situation, the smog that resulted from Indonesia, for example, environment. This is across jurisdictions. They had a lot of open burning, fires in Indonesia. Those fires affected the health of the citizens of Singapore and Malaysia. What do we do with that? The Prime Minister sends a note to the President of Indonesia saying, you really need to pay attention to this, but what else can be done as well?
Could I just mention very quickly, sorry. Just in relation to that, there would be the International Court of Justice. But the problem with that is you have to have the state parties agreeing. And if they don't agree, you don't get there. So there needs to be something else.
Now, your specific question is on our annual problem about, the haze. Now, at this stage, it's more by persuasion and education. So, which has been going on for 20 over years. But the winds keep blowing in the direction of Malaysia and Singapore. We find that Malaysian companies are also responsible when they have, setting up new plantations in Indonesia. So perhaps the environmental law could be amended to provide for extraterritorial commission of offences. That means if it's a Malaysian company incorporated in Malaysia, right now criminal law has the offence must be committed within the territory. So I do not know whether under the environmental laws, whether there would be a provision which says if the commission takes place outside the jurisdiction, but the effects of that is felt within the jurisdiction, then that is sufficient to give us nexus. So the best thing is to go and look at our environmental laws and see whether we have that extraterritorial component, because pollution of our skies is within the territory. And it is something I think for the prosecution to think about, because the powers lies. But civil jurisdiction, there could be, if the same principle of effects of commission of an environmental offence outside jurisdiction affects you within jurisdiction, and the commission person or entity which commits that crime is linked, perhaps there can be a test case to see whether a civil suit can be taken out against those Malaysian companies. But it's very hard to say which company committed that offence, because there could be 100 over companies with thousands of acres of plantation, all simultaneously committing. So how do we pinpoint and say it was that company? Maybe that's where you need the drones to go and survey, in the interiors of the forest, who is actually committing and setting out fire. So maybe we need that kind of technology to detect the culprit who strikes the first matchstick.
I will provide also a comment from the area of human rights. As you know, in Europe, we are quite proud of our jurisdictions and our legal systems in all the variety of those. But at the same time, we subjected ourselves to the jurisdiction of the European Court of Human Rights. This is probably the most successful court of human rights, considering that it has a actually working enforcement mechanism and highly prestigious jurisprudence, though diverse. It is not that it's a solid block of holdings. There are different winds blowing. However, by and large, it is very respectful jurisprudence and very respected decisions. However, what happened is that through the more than half century of the functioning of the European Court of Human Rights, it's become the victim of its own success in that it cannot handle the caseload anymore. And now what we are discussing among the European Council of Europe community is that we have to bring back the cases before the domestic municipal human rights bodies that would disburden the ECHR, the Strasbourg court, because it's choking. And yes, it just cannot process them. So firstly, there are cases are being dismissed on the under the on the foundation that the cases has been already resolved and that there is an answer given. Secondly, there are incentives given to the national jurisdictions to create mechanisms, municipal mechanisms that would ameliorate the influx of human rights cases. Yeah, there is a sine wave of this popularity of international courts and then diversion to national jurisdictions. Look what happens, I would say that there is a very positive thing that the ECHR establishes the jurisprudence, but then implementing the norms that result from this jurisprudence is now being returned to the municipal jurisdictions. Look what is going on with the International Court of Justice. You wait for decades for the resolutions. So again, there is a want for some kind of not as cumbersome procedurally and time-wise and cost-wise solution. Within the United Nations system, the solution that was meanwhile adopted is the administrative dispute tribunal, internal dispute tribunal of the United Nations. Even though the functionaries of the United Nations should, lacking a satisfactory solution, bring suits before the International Court of Justice, simply neither the court nor the functionaries could afford it. So hence the internal disputes between the staff members and the organizations are handled by the internal dispute tribunal, administrative tribunal. So we need, I think globally, we need solutions that are fast these are the regional or targeted mechanisms are probably the way to go.
I was just told that the backlog is piling at all these international tribunals. The procedures are getting cumbersome because the minute we start becoming legalistic, that is a problem. So we stay away from creating more court-like structures. We perfect what we are best at through dialogue. Its enhanced dialogue is mediation. But I think the fastest way is a dialogue. What we want is a speedy resolution. And if it takes a diplomatic note to solve the problem, I think that is the best approach. What we want is to find a solution, but there can never be a permanent solution which is binding and enforceable, right? In an international era, international realm. So, but what we hope is, for the time being, that dispute is not a thorny issue, and it's considered resolved until there's something to spark it out. And then, what we need is that continuous engagement and dialogue, the lines of communication, because in industrial education, we tell them, do not come to us, go for the preventive. So that's where human resources management is coming. In all my talks to a local audience, I tell the human resources is the most important in an organization because you must nip the problem in the bud. So whether it's trade or crime, it is understanding what creates that problem. Which means being aware that anything can potentially lead to a legal dispute. So nip it in the bud.
I'll just make one final comment. The European Court of Human Rights have recently reduced their backlog from 105,000 cases to 67,000 cases. And they did that by way of an examination of those matters that there'd been a decision on the legal issues, and they looked at jurisdiction and got rid of a great number of the cases. But the staff requirements to do that were astronomical. From my jurisdiction in Australia, which is Victoria, the Supreme Court had such a backlog and was so overburdened that they introduced a compulsory mediation system, and no case goes to trial until such time as a mediator has certified that it is impossible, in his or her view, for the matter to be resolved. And as a consequence, 90% of cases are now resolved on mediation.
I'll open up to the floor.
Thank you. Julian Stargard. I wanted to I wanted to address 3 points that arose in the panel discussion. One was on international trade disputes between corporations. And of course there's the WTO mechanism, but that's between nations. We heard yesterday references to the UNCTRAL commercial arbitration rules and Myanmar's recent adoption of the New York Convention and those rules. There has been a massive growth in both commercial arbitration and commercial mediation in a kind of ad hoc resort to finding an international method of dispute resolution. As an active mediator and arbitrator, my comment on that is neither mediation nor arbitration function as equitable dispute resolution mechanisms without a robust rule of law judicial system to back them up. Parties need access to law as opposed to mediation, which, as Judge Sithamparam aptly described, is enhanced negotiation. So that's one thing. You have this commercial dispute resolution by alternative dispute resolution. The second thing I wanted to mention was there was discussion about the lack of compulsory international dispute resolution mechanisms and the ICJ's rule that both parties need to agree to submit to the jurisdiction of that court. There is one international tribunal which can exercise a compulsory jurisdiction, and that's the law of the sea arbitration process, which is a very hot potato politically in this region right now. I just wanted to mention that and throw it into the air for people to think about. And then I wanted to briefly mention something from my own personal experience, which was the Comprehensive Plan of Action, which was a treaty between states of first asylum and states of resettlement under the UN auspices to deal with the Vietnamese boat people problem. And this set out a framework for refugee status determination, which was then implemented nationally in the states of first asylum. And although the framework of rules was the same for each country, the implementation of those rules in each jurisdiction was very different. In most jurisdictions, there was no judicial review. In Hong Kong, there was a lot of judicial review, and most of it did not focus on whether or not the person was a refugee under international law, but rather on technical faults at the adjudication process. I just wanted to mention these 3 different processes.
You see, in a domestic setting, we have all the processes available, but no system is perfect. Sometimes it's a question of logistics. We created the industrial court as an alternative to the courts of law. But the minute we tried, there was, in the course of the 47 years, or 49 years, the tendency is to adopt the same procedures as the court of law. And so we are now at the stage where we have make a conscious effort to regain the original intent. So that's where I think the prevention of the dispute is important. So it's through the human resources personnel who can spot the trouble. Same thing in a marriage. Why wait to go to the divorce court? Be mindful of what can aggravate a situation. So I think we owe it to ourselves and to our colleagues or family members to be mindful that it just doesn't originate out of thin air. There's always a progression in dispute resolution. The thing is to be aware what causes the tension and take steps at that earliest opportune moment to resolve it. Sometimes it's just changing your perspective. It's an issue, or it can be a non-issue. Okay, so it's something. Sometimes you just frame it in our minds. It's not a problem. It is a problem. That's all I have to say in this continuous process of trying to find a solution. Now, I like the idea of what Justice Downing said, that there will be a merger, because I've attended a few conferences on the law Asia, and it's the same sentiment being expressed that there will be convergence. It may or may not happen in our lifetime, but it is a journey, and this journey can only be promising if we have conferences like this to share our ideas and thoughts. Thank you.
It's the journey for the common law, I think, has taken 1,100 years so far. So maybe it will be another 1,000 years before we have total convergence. But just on the point in relation to arbitration, there is within the region a feeling that many corporations wish to arbitrate disputes, contractual disputes or otherwise, through an international arbitration system rather than the domestic system, because they don't trust the domestic system. But ultimately, unless there are guarantees written into arbitration agreements in relation to enforcement out of the jurisdiction from which the dispute has arisen, there are major difficulties of enforcement of an arbitral award. You can register it, the courts may be able to do that, but to actually get it enforced is an entirely different process and very difficult in most of the jurisdictions. So that if you have an arbitral system, you have to be able to execute on assets out of the jurisdiction where the dispute arose. And that's something for people to think about until the jurisdictions which are going ahead with foreign investment at a great rate, and the foreign investment rules are outpacing the rule of law, including enforcement. No point in having any decision unless you can enforce it. And that's what's occurring.
One reflection, because I know that judge is waiting to take the floor there. I have this reflection that we started from discussing how international or multinational approaches are being used in national jurisdictions, and then we again today are jumping on the idea of supranational adjudication and dispute resolution. I have no answer. Obviously in Europe we have both. We have to know the Council of Europe standards when we adjudicate cases in municipal jurisdictions in Europe, and we have to know and apply the European Union standards in adjudication of cases in Europe. But we do have also the court mechanisms for the dispute resolution if it doesn't work. But I still would insist not trying to resolve the chicken and egg question, which should go first, but for me it appears obvious that we need to learn from one another, and we need to know the international approaches and multinational and different national approaches in order to enrich our knowledge of dispute resolution, because we aim at the same point in the end.
Judge Nico?
Thank you. Sorry, a little bit loud. First of all, thank you very much, panelists, for your valuable contributions. I just want to be in the style of this morning, not giving too much reasons, just making two statements. One statement is cloud computing, the other statement is Bahrain. I'll explain right away. Cloud computing is a good example, I think, of the problems we will have. My good colleague Rowan Downing spoke about it, giving up sovereignty and so on. I'm just not giving the solution, but putting the question, asking the question: what can you do if a country like Yemen or a country like North Korea, there is a cloud and there are difficulties? You have to give up national sovereignty. You have to find a solution. Therefore, it's very important that international organs will speak about that. It will be a bigger problem in the coming years. I'm convinced about that. The other remark, very shortly, is Bahrain. Today on the internet, I have read that the government of Bahrain has said we are going to develop an international court of human rights for Bahrain. And the first reaction of NGOs was, it's a laugh, because we don't think that it's really a court of human rights. And this brings me to the final statement I want to make. For the judiciary, in which state you are, it's very important to be trustworthy and credible. If people don't think that it's something of substance you can bring, you can forget about the rule of law. Thank you.
Any other questions from the floor? No? I'll have one point to summarize, and that's what LexisNexis will take away from this. We always talk about it, but we've never surfaced it just as clearly as Judge Downing did today. Language, is one of the barriers. If we can overcome that, there is a lot more sharing that we can do. And Judge Milart said, international law as well as national laws. So we need to know both. And national laws means national languages. And there must be a lot of information and learning and insight and guidance we could seek from national laws. But if it is not, presented in a language that we comprehend, then it is lost and it's limited. So I think, that is something that LexisNexis should take as a lesson moving forward. We need to think about this. We need to ponder this and think about how better we can provide the content that we are currently providing or will provide, and make it consumable to as many individuals as we can. And I think that is the takeaway that I have from this session as well. If there aren't any other questions from the floor, I'd like to wrap up the LexisNexis Rule of Law Conference, the Transnational Dialogue, by thanking our panelists today and thanking everyone here for engaging with us and being so forthcoming and passionate about your topics as well. And please give yourselves a round of applause for that.